Alrighty, I've noticed a couple people starting to log on, so I'll go ahead and get started. I just want to thank everyone for joining us tonight, and we're going to be hearing more in this webinar, more about salary data and contract review tips with Kyle Claussen, the CEO of Resolve. In this webinar, we'll hear from him just a little bit more about his company and everything, the physician contracts that they have. And while everyone's still logging on, I'll give Kyle a minute and everyone else a minute to get kind of situated. I just wanted to take a minute to introduce myself. My name is Peyton Jennings, and I am the physician engagement coordinator here at Practice Match. Some of you attending might already know me because I work very closely with the physician promoters. And if you want to know more about that, feel free to message me about that. So hopefully, since you're here, you kind of already know a little bit about what Practice Match has to offer and what we are. We offer many resources to physicians, residents, fellows, nurse practitioners, just kind of to help you guys with your experience in Practice Match. We also have a free CV Rebuilder and CV Review. We have scholarships, we have virtual career fairs, which if you attended the one before, we also have free physician immigration guidebooks, and as well as free physician practice path career guidebooks. So if you have any questions about that, feel free to message me after this webinar is over if you're interested in learning more about any of that. And please note that your microphones will be silenced throughout this presentation. We'll have time after Kyle's done presenting for a Q&A session at the end. So if you have any questions throughout this webinar, please put those in the Q&A box and we'll touch base with those at the end of the presentation. So Kyle, you can go ahead and take it away.
Okay, very good. I appreciate the introduction, and I hope you guys can all see the screen, the slides that are up there. There's a chat functionality to this and a Q&A component. And so I would much prefer to answer your questions than to sit here and talk to you and click through slides. So feel free at any point in time during the presentation, throw those in there. And I'm happy to try to answer those if I can. So a little bit about Resolve before we get going. Resolve is the largest, one of the largest, if not the largest, contract review companies in the country. We talk to physicians in all 50 states, in all specialties, and we've been doing it for over a decade now. So we feel like we've got a pretty good idea of what you're going to see in the market, and we've got some things we want to show you on comp, and just some tools again that you guys can utilize as you get into not only looking for your job, whether that's first job or a career move, but also knowing what to ask, right? And also finding out, kind of maybe some of those red flags that you want to think about. So with that being said, I'm going to get going here and take my video away, and we'll start to talk about physician contracts in 2022. So the first thing I want you guys to think about when you're looking for jobs and also reviewing contracts is just what the market for physicians looks like right now. It's a little bit different in 2022 than it was 3 or 4 years ago. And so the shortage of physicians is not new. I think you guys all know that, and that's been well publicized. Somewhere between 37 and 124,000 physicians we're going to be short across the country, but that varies by market pretty dramatically. So there are going to be some areas that are very, very short, and some specialties that are very short, and then there's going to be other areas and other specialties where there may be a surplus. So understanding supply and demand in the market that you're looking at is really important. Understanding consolidation and what's happening right now in healthcare. Roughly 74% of physicians are now employed, which means they're not in private practice. They're not working towards becoming a partner. They're with a health system or an academic center, right, or a hospital. Or maybe even a larger private equity group, that's out there. So it's no longer that you're maybe necessarily negotiating with a colleague or potentially being an owner with a colleague. That's certainly a minority position today. So just keep that in mind of who you're negotiating with. And then the third thing I'd have you think about is just the different priorities right now for physicians. There's obviously COVID changed a lot of things across the country, but there's certainly more access now to some telehealth positions than there were in the past. We're seeing a lot more emphasis on work-life balance and what call schedules look like, and those being higher priorities sometimes than even compensation. And so I think you need to understand all three of these areas and really start to evaluate what those look like for you individually. Because when you look at your options, okay, this is just a very overgeneralization, but I want to give you an idea of what the market looks like. When you're in a hospital system or when you're, in an employed model, generally those have guarantees that are higher, meaning more compensation up front than you would see from a private practice, but they also come with less control and usually less upside, right? And so that's in the form of you're not going to be your own boss at some point. You're not going to usually have the option to buy into ambulatory surgery centers or ancillary revenues, right? And so that's kind of the less control or less upside that's on this graph. But they do offer more in guaranteed pay, larger signing bonuses, student loan reimbursements. And so some things are obviously very beneficial for you. The other side of the scale is lots of autonomy, lots of control. You're running your own practice, which is your own, right, small business. You're going to have guarantees that are lower, but potential more upside down the road. And so we've got kind of this unicorn setting and also the don't go here setting in the other two corners. Obviously, you probably want, right, as a physician, as much autonomy and upside as possible with also as much guaranteed money as you can get. And so that's kind of that unicorn section. Does that exist? Fairly rarely, right? Most of the time, you're going to fall somewhere in the middle on this graph. Certainly, anytime that there's not much being guaranteed and no control and no upside, those are, kind of red flags. And I think there's probably options out there that are better for you than those. So that's kind of a very overgeneralization again, image for you to take a look at, but something to think about as you get into your job search and what you're looking for. So when you start to think about your strategy on how you're going to review your contract and how you're going to go through this process, right? The first thing that you're going to want to identify is what your priorities are. So going into the discussion if geography is most important to you, or if it's money, or if it's scope of practice, or if it's time, right? Kind of that call schedule stuff we talked about. That's step one. So make sure you understand what's going to work for you and what you're going to focus on in not only your search, but in your contract review and your negotiation. Okay, the second thing is that you really need to know what the market is bearing right now for your specialty for that location. So knowing market data, there's survey data that's out there, there's crowdsourced data that we're going to talk about. You're going to have competing offers. Hopefully, if you're doing your job search the right way, you should have 2 or 3 offers side by side. And so then you're going to take the next step and compare those offers. We're going to talk about some terms to review in that tonight. And we're also going to talk about negotiating and how you actually do that in good faith and not, asking for things that you shouldn't or things that are unusual. And kind of what type of wiggle room there is usually, in these documents. So that's a quick outline of where we're going. So first thing we want to talk about is market data, right? I'm going to assume you're going to figure out the first part about where do you want to live and what's most important to you, whether it's money or time or, something else. So once we get past that step, there's different categories of market data, right? And we talked about survey data. And what I mean by survey data is things like the acronyms you're going to hear are MGMA, AMGA, AAMC, Sullivan and Cotter, Pinnacle, some others that are out there. There are very large surveys that the health systems and employers will utilize for fair market value and for compliance purposes. And a lot of times you're going to see those referenced directly in your contract for we can't pay more than, right, maybe the 90th percentile of MGMA. If those things are being referenced in your document, it would be really good for you to know what MGMA says for your specialty for that area, right? Or if it's a blended rate of the 2 or 3 different surveys, trying to get as much of that data as you can in front of you is really important. The second thing that I would have you do is take a look at what has recently happened in that area for your specialty, right? So this is what the crowdsourced data that we're talking about. These things, some of these things are paid, right? MGMA data is not free. Some of the crowdsourced data is going to be accessible and free for you. These are free tools on resolve.com you can go to, but you can go through and you can see what an ENT, contract was offered in the Eastern area within the last, 2 or 3 months, right? So the benefit of crowdsourced data is that it's going to be more live. MGMA and all these other surveys are going to be roughly a year old. And so obviously things change quickly in healthcare and you want to know what is, happening today and yesterday so you can be, informed on what's fair and what's not. All that being said, your best data point is going to be the other offers that hopefully you have, right? And so I know you guys are potentially had attended a career fair today with Practice Match. Having 2 or 3 offers side by side at the exact same time is really your best snapshot into market value. And so knowing what you can walk from one offer to the next, right, is really important, because just because MGMA says one thing and just because the crowdsourced data says, maybe something that's close to that, if all of your offers in that location at this point in time are different, that, is good for you to know when you start to negotiate, and understanding how hard you can push on certain things. Okay. So understand those 3 areas of data and make sure you've got other offers. That's really, really important. Okay. So then you're going to get to the comparing your offer standpoint. So you hopefully at this point you've got, potentially a letter of intent, or you've moved on to the full contract stage. You need to start to issue spot, and this is where I think, utilizing a service like ours, or finding a good, other service healthcare attorney out there that can help walk you through some of this is important. I would start to look at these 3 main categories as kind of where you need to start to issue spot. Okay, so scheduling and duties, and kind of just what you're expected to do day in and day out, is bucket number 1. Okay, and so as we walk through that first bucket, where you practice and what days of the week you practice and how much call you take, those 3 things are often not defined very well. And so if they're not defined well, or if some of those things are going to be really important or potentially deal breakers for you, those should be either delineated or discussed or listed in an exhibit somewhere, right? So you're not questioning what your call is going to look like. If there's 10 satellite locations and you only want to go to 6 of them, you should have the other 4 excluded, right? That only makes sense. So making sure you have definition on the things that are important to you is really, really key in that area. Other things to think about in the scheduling and duties section, most contracts are going to start out preventing you from doing outside activities. And so this would include anything from not only moonlighting and doing locum work, but also other side gigs, right? Things that are non-clinical in nature that you might want to get into. You almost always have to start out asking for permission on those things. And so if you already are engaged in some type of consulting role, or you already have a side gig that you're working on, I think it's really important to change that language, or at least have those things carved out, so you're not potentially in violation of the contract, right? From the start. That would flow through to intellectual property as well. A lot of times, some of the side, consulting roles that you're in, you may be developing intellectual property. If that's the case, devices, come with patents and copyrights and things like that. Make sure you've got intellectual property language in the document that protects you, and that who keeps, that intellectual property if and when it's developed. Okay, a couple other things in the scheduling and duty section. If you have concerns on supervising APPs, right, mid-levels, nurse practitioners, physician assistants, things like that, make sure the language protects you on that. Make sure you know that you have some control over saying yes or no to doing those things. And or if it's an expectation of the employer that you're going to do that, again, having that detailed out so you're not surprised later on about what's going on is very, very important. Okay, and then also paying attention to time allocations, meaning if you want time for administrative work or research or teaching, that those things are carved out in those sections. Okay. The second area of issue spotting should be anything that revolves around compensation and how you're paid and what you're paid. Okay, this would include benefits as well. Most of the contracts that you're going to see are going to have some type of guarantee or base salary along with a production model. There are some quality components that you'll see in contracts. Usually that's less than 10% of the total comp. It's primarily still base and production. You will see some type of, ancillary things like signing bonuses, relocation allowance, potentially student loan forgiveness or retention bonuses on, depending on the employer and the location that you're in. You may, if you sign early enough, see a residency fellowship stipend, right? Which is almost like an advanced signing bonus that they're paying to you while you're finishing training. And then other things like CME and vacation, paid time off. Some of those benefits are going to be listed out. We often get the question of why aren't the details on health insurance and retirement plans and things like that listed in the contract. The reason for that is because most of those things are non-negotiable. They're third-party contracts, right? They contract with Fidelity or Charles Schwab or somebody to set up their retirement plan. They can't negotiate that or change that on a one-off basis for you. So those would be things when you start to talk about negotiating in good faith, which is coming up here, to know what's changeable and what's just absolutely not changeable by the employer. Okay. The third area, and then there's a question that came in, which I'll get to here in a second. The third area is termination. So anything that revolves around how the relationship ends, you should be paying very close attention to, especially in the market that we're in now, with most in a employed setting. Those contracts are 1 to 2 years in nature. There's not a lot of long-term protection, and you're not going to be a partner where you own the business, right, anymore. And so it's most likely that your contract is going to end at some point in time. And so you should know what that looks like. So understanding notice periods and, how you have to deliver notice if those things come up, understanding if there's for cause versus without cause termination. You don't want to be terminated for cause, right? That means you've done something wrong. And so if there's provisions in those sections that are very broad, for example, like you've just violated a policy or procedure of the employer, you may not know what all those policies and procedures are. So trying to limit those as much as you can would be to your benefit. Okay, so understand how the contract terminates, understand how much notice you have to give, and then start to look for other things that are going to be financially important for you, like, do I have malpractice insurance and tail coverage post termination? Okay, if you don't have tail coverage, meaning if you have to go out and buy it on your own, it can be expensive. For some specialties, it's a 6-figure number. All right, and so if you are unsure of that, or if you skipped that analysis as part of your, review, that's going to be as important as a signing bonus for most physicians, right? It's an equal type number usually. Okay. Non-competes, we're going to talk about that in more detail here in a second, but non-competes really reduce your leverage on any type of renegotiation or on any type of potential termination and where you're going to go down the road. So I'm going to give you an example of what a non-compete looks like, but those are things that some states have disallowed entirely because they think they're poor public policy for physicians and for healthcare, but most states still allow them. Most states are still going to analyze them on a case-by-case basis, and therefore, if you've got one, you should be trying to drive that down to as short a time frame as you can with as small a geography as you can. And again, we're going to look at that here in a second. Other things to pay attention to, if you have to have any type of repayment of a production bonus, or excuse me, of a signing bonus or relocation allowance that they've given you up front, you need to know what those repayment obligations look like. If you're on a heavy production model for your compensation and you're in the positive, let's say you're positive in Q3 and you terminate right before the end of the fourth quarter of the contract, is that production bonus going to be paid out or not? That's a question you should be asking and looking for. Okay. And then also if there's other liquidated damages or force majeure clauses, those things are kind of wrapped up in the legalese of each contract, not something that's going to stick out to you necessarily, but can cause financial problems for you and can cause the contract to terminate immediately. So force majeure basically is a clause that says if there's an act of God, right, during the term of the contract, either side can walk away from this without any notice, without any harm. The problem is that pandemics usually fall within that definition. And so you can imagine with the last 2 or 3 years with COVID, who gets to decide if we're in a pandemic or not, and how much notices need to be given if there's a either a cut in comp or if there's a furloughing of physicians and things like that. I mean, all those things are problems, right? And so if you can eliminate a lot of that in your contract, it's not that they can't still let you go, right? But they're gonna have to let you go without cause and give you the proper notice and give you time to think about what your next step is so things don't catch you off guard. Okay. So with that, there's a question that came in on, do we analyze data or provide data about salaries for male versus female physicians with the same qualifications, specialty, and geographic location? The answer is there's a lot of studies out there that have analyzed this. Do we sort data that way? We do not. MGMA, I don't think does either at this point in time. That being said, I mean, I think analyzing any offer, whether it's male or female, is important for you, right? If you're coming in and negotiating, if you are a female, for example, I would want to know every single offer that's out there, and I would not want to negotiate against other female contracts. I would want to negotiate against all contracts, and that's certainly, I think what you're getting at, and that is the point. We do see discrimination happen, and it's blatant sometimes, and because we see thousands of these from the same employer, that's a vantage point of the the seat that we live in. Where sometimes there's a signing bonus on one offer and sometimes there's not on another one, right? And so it forces, the individuals to make those asks and make those requests because, sometimes they're just not there. So we're going to get to that here in a second too, but a good question. But the answer is no, we don't sort the data that way. Okay, so I want to walk through a example comp model here of the 3 most likely types of comp plans that you're going to see in your contracts. You're primarily going to see, like I said before, a base salary being offered with some type of production. Those production models are going to be based on either work RVUs, a collection model, or a gross charges / billings model. That one's less common. But the analysis I want you guys to think about is the same for all 3. Okay. So when we look at your contract versus the data, because hopefully at this point you've done your homework, you've got all the data in front of you, now you've got a contract, you're going to start to do the analysis. If your base salary that you're offered is $200,000 and you look at the data and the median's also $200,000, you think, great, I'm being paid fairly, it's exactly where it should be. Don't stop your analysis there, okay? If you also look at your work RVU production model and that paragraph says we're going to pay you $40, right? So the number on the bottom, $40 for everything that goes past 3,000 work RVUs, that may or may not, depending on where you're at in your career, mean much to you, right? You don't know how many patients you need to see to get to 3,000 work RVUs. You don't know if 40 is the right number, potentially. Those things vary by market too, and by specialty. So, reimbursement for family medicine is not the same as what it is for plastic surgery, for example, right? And so the multipliers are going to be different. The thresholds are going to be different. And so if you look at the data, and the data says roughly 2,500 work RVUs equate to this $200,000 compensation number up here, when I look at that, I say, okay, why do I have to produce an extra 500 work RVUs without any compensation, right? So if I get to 3,000, that means I get no bonus in this situation. Whereas fair market value says if I get to 3,000, I should have a bonus of 500 work RVUs times 40, which is roughly, not roughly, $20,000. Okay. So in column 1 here, I would say that offer is off, right? Is short by roughly 20,000. And you can take that same analysis and apply it to a collection model or a billing model. So one more time, just to make sure we're all following, make sure the base lines up with the production threshold and the multiplier is also close to fair market value. So if you have a base of 200, the median's 190, you're thinking even better, right? They're paying me 10,000 more than the median. However, if you look at the production and they're asking you to produce 600,000 in collections and the median's only 500 and the multiplier is 30, this is $100,000 that you're short 30% of. So you're short 30 here, you're plus 10 here, which when you add that together, it's still short 20, right? So these first 2 columns are both short $20,000 from where the market says they should be, roughly. Okay. So be very careful on that, of how they've got those things structured and how it's set up. The other thing we talked about from a leverage standpoint is non-competes. Okay. And so this is a tongue-in-cheek, right? Welcome to town, now leave. But that's effectively what happens in a lot of these situations. So a non-compete says that when this relationship ends, right? So when the contract is no longer in existence, you terminate or I terminate, that you can't practice for a certain amount of time in a certain area. And so the map might look like this, right? If there's a health system or a practice that has 7 locations, right, which are the 7 circles that are on here, and if it's a 3-mile radius on each one of those, you might think 3 miles is fine because there's lots of options. But if you didn't actually take a look at the map, there's all these different circles and it turns into a much bigger problem for you. So understanding where they're applying the non-compete from is also just as important as how long it is and how geographically restrictive it is, right, in mileage. There also can be exclusions, right, in these, and there should be exclusions for how the contract terminates. So if it's not your fault, for example, you didn't terminate the contract, you were happy working and they just gave you notice, should your non-compete apply? The answer is it will apply, probably, if you don't try to carve that out. Or if they're in breach of contract, they just stop paying your production bonus and you quit. Should you have a non-compete? I don't think so, but the language probably says whenever this contract terminates, regardless of how it terminates, that's how they're structured. Okay, so just be very careful on little things like that, on not just the time, not just the geography, but also when it applies, how many locations it's applying to. Are there any carve outs for academics or the VA or other things, right, that might be helpful? All of those things matter when you're trying to look for your next position. Okay. Another question came in here. Is it true that inpatient positions, so hospitalists, ICU, et cetera, are not as much of a problem because the physicians not taking their patients with them? There's no panel that you can move to a competitor. I think the answer to that is that gives you more ammunition, right, to say that this shouldn't be applicable to you. However, most states don't have rules that say this only applies to outpatient positions. There's only a few states that have banned them entirely. So do I think that gives you a better position and a better argument? Absolutely, right? Because the goal of a non-compete, or the reason that we as a society allow non-competes just generally, is that we say for any business, not just healthcare, if an employer invests time and resources into an employee, they shouldn't be able to steal that knowledge or that patient base and walk right across the street, right? So we allow them for those reasons, but in an inpatient setting, right, or ER, right, would be the same type of thing. You don't have patients that are going to follow you. You're just seeing what's there, right? So I think it's less likely to be enforced, but but I have not seen many that carve those out by specialty. So I think you're still gonna have the same problem, is my point. You're still gonna have to try to get those removed. Okay. All right. Next slide is we're gonna talk about negotiation. Okay. How you go about asking these questions is important. I would encourage you to negotiate everything in good faith. I would encourage you to understand what BATN is, what your best alternative is to if this negotiation fails, right? Do I have an option B? Do I have an option C? And I also would encourage you to understand that every single employer is probably going to tell you that the contract is standard, that they don't change them, that 100 or 500 or 1,000 other physicians have signed them just like they are. I wish that was true for you and that you could trust that. The problem is that it's not. Over 85% of the contracts that we see have some type of change in them, whether that's numbers or language or anything else. And I'll show you an example of some communication on that in a second. But I think understanding what can and can't be done. We talked about retirement and healthcare and things like that, about how those are non-negotiable items. There may be other things that are less important to you, that or less important just in general to the situation. And so I think you want to ask for everything at one time, so you're not piecemealing a negotiation back and forth, because that's frustrating for an employer to deal with, because they don't know when your last question is going to come in. But I also would encourage you to not ask for just the deal breakers. I think you should want a fair contract from the start. And so if there's things that you think aren't fair in there, you should be asking for anything and everything that makes sense to you and that you can justify reasonably, with data, hopefully, to help back you up on that. Okay. So when we talk about all contracts are standard, you have to make the ask, and this is exact language from an employer. After we had gone through and asked for changes to the non-compete on this contract. You guys can read this, but I'll read it for you as well. The contract we offered to Dr. X is the same contract we offer to all of our employed physicians. It's been reviewed and vetted by scores of attorney over the past 15 years. We typically don't make changes, right? But here comes the but. This being said, we did provide a fairly significant and rare accommodation to him or her in the form of a relaxed restrictive covenant, which is the non-compete. Okay, as we were advised, it was an important issue for him. So that example, I think, is spot on. It's the reason it's here, is that they all want to say, and it may be true in a lot of the situations, that the contracts are the same, they don't change. However, that being said, we find that if you have multiple offers, if you know that things are different, right, in that location, and that there's fair things that you're asking for, you're not asking for something that's completely 180 from the position that they started with, we often see them making changes. Okay, so you have to be able to make the ask. You have to understand what's fair, and base all of your discussions off of that, and trying to find, hopefully, what's a win-win for them, because recruitment's hard, right? You guys are a valuable asset. They definitely want you there. They also want to make sure that there's good retention, that you're not going to just take a job and stay for 3 years and leave. And so having a structure in place that hopefully you're happy with is really important to them, and it should be important to you guys too. So with that being said, I am happy to answer any and all questions. If there's questions that you don't want to ask in the group setting, I've got my email up here as well. I'm happy to try to field those tomorrow for you if you send them over. If not, I will turn the chat and the Q&A open to you guys, and you can ask anything you want. And I see somebody with their hand raised. Peyton, do you know how to turn the mic on, or do they have to type them in?
Sorry, I was still muted. Hang on one second.
It's okay.
Hold on.
Okay, here one came in while you were looking for that. Our spousal physician hire is something that you see explicitly in a contract. I think the question is meaning they have to have an offer for both of you, so the offers are contingent on each other. I would say that the answer is yes. I mean, I would encourage you not to execute a contract unless, right, if both of you need a contract that they would prepare both at the same time, you can execute them at the same time. That would remove any need for contingencies. You could put something in if you're concerned on after the fact, right? Meaning if my spouse loses, his or her job, that my non-compete is then waived, right? So I can go find another job across the street if I need to. I think there's ways to safeguard and protect on that, but I'd want to know the specific situation to give you the right advice on that. Second question is, what's the best method to approach contract lawyers? Meaning, what is the best time after receiving a few contracts, et cetera? So I always think earlier the better, right, on this. And most of that comes from what we're doing right now. The clients that I find to have the most success and the ones that I think are happiest with the process are the ones that engage us early. If you hire anybody, right, I mean, it's no different in healthcare. If you come to anybody last minute, you're really putting yourself up against a wall, and you're really removing leverage for yourself. And so if you show up to me and say, hey, I've got a contract, I need to have it reviewed, and it's got to be done by Friday, or I have to sign by Friday, well, that it's unlikely the employer is going to move much on that, because they need a yes or no answer in 2 days. So I think you should still have it reviewed. I think you want to know what you're getting into, but I think the success rate of having them make changes in that short period of time is less likely. Not that they won't extend deadlines and push things back, right? Certainly now, if it's September and you're not starting until July, it's probably an artificial deadline. You've got lots of time, but sometimes it's not. Sometimes it's a real deadline. They've got 2 or 3 candidates. And so I used to be careful on that, and I would start the process as early as possible.
I'm going to allow Leslie to talk because her hand's still raised if she still has a question.
Yeah, I was just going to say, I don't know how to do it on my end. So, here we go.
Never mind. Okay.
Informal advice on how to start the discussion, i.e. language use on email requests for changes to the contract. Who do you usually send those to, et cetera? So if you've got an offer that came in, I always tell people to go back to whoever gave you the offer. Okay, so that's who you should be addressing your questions back to. Don't guess at who's going to be fielding the contract questions. Just take it back to them. Let them decide who should answer it. The other part of that is language to use and example language to use. I mean, I think you want to be as short and sweet as you can, and let the document and hopefully the edits to the document speak for themselves. Now, that being said, once they see the document, they're going to want to have a conversation on it. But I think something to the effect of, I've reviewed this, right? I've compared it to my other offers. I've, hopefully talked to a healthcare attorney on this, and, these are recommendations and things that are important to me. I think that's as simple and as straightforward as it needs to be. And then please let me know a time to discuss, right? Or a time to talk to my attorney and discuss if you're having them do that. So you don't need to go through bullet by bullet and lay out reasoning and justification. I think a lot of that's better done by language in the contract and the conversation. But good question. Some of those things change too. I'm just going to keep talking on that point. I think some of those things change too on who you're negotiating with. So, if you're, even though it's a minority position right now, if you're negotiating with a private practice and you're going to be colleagues with this person at some point, I think there's probably more of a relationship there that you need to have and build and understand how they're going to treat you in the future as a colleague and a potential partner in a business, versus if you're working for a large health system and you're talking with administration. Not that you don't want to have a good relationship with them, because you do, but there's also turnover in those positions more frequently than probably you would hope. And so the person interpreting your contract in 5 years may not be the same person that's interpreting it today. And so I think you just need to, treat the situations a little bit differently. It's unlikely that a partner, right, is going to leave a private practice, versus somebody in administration could move around. Okay, next question. Do you advise to seek a contract attorney specific to a specialty, i.e. surgery? Does your company have specialists or surgical specialists? I think the most important thing is having somebody who does, first of all, kind of the first filter is healthcare law. Okay, so when you talk about specialists, it's probably a little bit broader than what you're talking about. So there are physicians that do, right, family medicine versus surgery, right? Those are two different specialties. In the attorney world, it's going to be healthcare versus like family law, criminal law, right? Something completely different. We see a high enough volume of these that we this is pretty much all we do, and so we're very specialized in the physician employment world of healthcare. We see all specialties, all 50 states. We don't necessarily have people that specialize in just one specialty, but we see such a high number of them that we feel confident and competent in all those areas. Is there any way to increase the chance of a large academic institution will be willing to amend a contract? Is a lawyer required? Obviously advisable. Yeah, obviously advisable. I mean, I think even if you decide not to utilize them at all from a negotiation standpoint, I think you want to know what you don't know, right? I mean, I think that's important. We do see academic institutions change their contracts. And so it's going to feel very much like every other employer that tells you that they're non-negotiable, but that may or may not be true. And unfortunately, it may or may not be true by specialty, by time, right? By the number of candidates that they've got at that point in time. So that's, again, a benefit of sitting where we do is we'll have a large employer, right, that you guys would all know the name of. If we've done, let's say 7 contracts in the last 7 months, and 4 of them they've made changes on and 3 they haven't. And so I don't have necessarily a good rhyme or reason for you on why those things happen, but I think it is very case specific on the location you're going to, the specialty you're in, and just supply and demand at that point in time for your specialty. So make all the asks. If they say no to everything, you can always still take the contract, right? I mean, it's really, really rare that they're going to pull an offer on you. And so I would tell you not to worry about that as much as probably you do. This is more of a comment than a question, but it's just says, I love how they're presenting standardized contracts as a way to combat the gender wage gap. It's a trend I've heard about with recent applicants. Yeah, I mean, I think there's different ways to frame, why the contract is non-negotiable. I think at the end of the day, right, it's certainly easier for legal, right, on their end to have contracts that are identical across the board. So I'm not faulting anyone for trying to do that. I also just think that it's a position that's difficult, right, for them to put into play, because there's always needs. And when supply and demand is weighted as heavy as it is toward the physician, there's likely, and you guys know this, if you go out and research and look at the job boards and contact practices in the area, there's probably multiple positions in almost every location for your services. And so they're definitely competing for you. And when they're going to compete, even though they want standard contracts, they're probably going to make adjustments here or there if it means you're going to sign with them. So it's, it just is what it is. Does our premium plan, which includes 4 contracts, use and analyze 2 contracts for 2 physician spouses? Thanks. No. So every individual has to have their own account or plan with us. So we don't advise 2 people, whether it's spouse or not, right? We don't advise 2 people under the same plan. Everybody has an individual relationship. And so the answer to that one's no. Okay, well, if you guys don't have any other questions, I will wrap this up. My email's up there. You can always utilize that. If you go to resolve.com, there is a chat feature. After hours, it's tough to get anybody to respond to that, but during business hours, certainly they can answer questions too. Peyton will have a discount code that we will send to her. So if you guys do want to utilize, any of the contract services, whether that's now or in the next, 6 to 12 months, you'll have a code you can use to get a discount. And I appreciate the thank you that just came through. If you guys need anything else, I'm happy to help, and you should know where to find me.
Alrighty, well, thank you for your time, Kyle, and thank you all for attending. Like you said, I'll be sending an email out to you guys anyway. So if you have any questions, feel free to reach out to me or Kyle. We can help you out. So, oh, you have one. Oh, another thanks. So.
Oh, good. Thanks.
There you go.
You guys are great. Good questions. Have a good night.
Have a good night, guys.
Bye-bye.